You will not be an overstay even if your visa expire if you made a valid application on time before your visa expire. Section 3C is important protection to become overstay of someone whose leave to remain application, who leave to remain expire, but he or she made an application on time. Now, the question is whether this is applicable in case of administrative review, whether this is applicable for appeal process, whether it's applicable for judicial review, whether continuous leave to remain will continue if you made another application in the UK while the other application is decided or not decided or in appeal stage. Viewers, my name is Suhail Ahmed. I'm a solicitor at SWF Solicitor. If you need any legal assistance, please feel free to contact us. Our contact details at the bottom of the screen. We are located in London and Milton Keynes. However, we can assist you anywhere in the UK through the Zoom, or WhatsApp, or online meeting, or even telephone consultation. Viewers, first question is, your current leave to remain will continue if you made a valid application before your visa expire. However, if you make an invalid application or Home Office refuse your application as invalid, say for example you didn't pay the correct fee or you didn't give the fingerprint, in that case it is a valid application, or you didn't provided or you haven't provided all the necessary mandatory document with your application, the Home Office return your application as invalid, your Section 3C leave to remain will come to an end. Second question, how long it continue? It will continue until Home Office make a decision. If the Home Office refuse your application, and if you do appeal, and you have right of appeal in the UK, then if you do appeal on time, then also your leave to remain will continue until final determination of your appeal. Next question, will Section 3C means your continuous leave to remain applicable in administrative review? The answer is yes. If you made a valid in administrative review of Home Office refusal, your leave to remain will continue. When you can do administrative review? When you don't have appeal right. So for example, PBS, all the application have no appeal right, so you can do administrative review. Number 3, will it applicable to judicial review? Say for example, your leave to remain refused, you don't have appeal right, administrative review is not applicable, you need to go, you have challenged the Home Office refusal under 5 grounds of unreasonable loss, unlawful proportionality, other grounds. So will your leave to remain will continue in that situation if you challenge the Home Office decision by judicial review? The answer is no. Generally, your leave to remain will not continue. However, if the court quash the Home Office decision, that case your leave to remain will be continue. Continue means it will reshuffle back. Right. Now the final question is, while your application is pending and you made another application, that is a tricky point. Now you can't vary your application under Section 3C subsection 4. You can't make a variation of your application. However, if you amend your application by making another application, in that case, it's a bit technical. So for example, I'll give an example. You are on PBS, point-based system. You made an application for a skilled worker visa extension. And while the Home Office has not decided your application, you married, now you want to switch to a family visa. In that case, you amend your PBS application, maybe you need to pay more fees. So you need to pay and made the later application validly. In that case, your leave to remain will continue until the Home Office decides. So you can't amend your previous application. However, after Home Office made a decision, you can't vary, you can't amend your application. You can, but that will bring your leave to Section 3C end. So for example, Home Office refused your application, you appeal to the Fast Track Tribunal. While your appeal is ongoing, you made another human rights application in that case, your leave to remain will not come. Your leave to remain will not continue if you abandon your appeal and solely decide on your new application. Okay, so this is the tricky point. So if you want to vary, or if you want to amend your application, you have to do it before your leave to remain, before the Home Office make the decision. After decision, if in the appeal stage, and if you abandon your appeal, and or the First Tier Tribunal refuse your appeal, yeah, and now you have chance to go upper tribunal within 14 days. You decided not to go to the upper tribunal. Rather than within this 14 days, you make another application. What do you seek? Or do you claim asylum? In that case, your Section 3C will come to end. So it is like this. The flow is going. While it go, your leave to remain will continue. In the appeal stage, if you can make another application. As soon as you continue your appeal, your leave to remain will continue. But if you abandon your appeal, or Home Office First Tier Tribunal refuse your appeal, and then you, rather than go to upper tribunal, you decided to make a new application, start from beginning again, 5 years up to High Court, Supreme Court, so will complete their continuous 10 years. It doesn't work like this. In that point, your leave to remain will come, your continuous leave to remain will come to an end. Administrative review, as soon as Home Office make a decision on your outcome of your administrative review, your Section 3C will come to an end. So this is how it works, and it is very important. Finally, if you, so for example, you have a current valid leave to remain, you believe you made a valid application, you got your visa, again another extension, continuary living, completed 10 years or 5 years, you apply for ILR. Now, if the Home Office found in any case on your first leave to remain visa, you didn't comply the condition of your visa, you did a fraud or deception with the Home Office, Home Office can bring to an end your Section 3C leave at that point and say, look, you don't have valid visa, although you have share code, you have BRP card, but you don't have valid visa because you breached the condition, and Section 3C leave will come to end. So if you are applying for ILR, or if you are applying for any further leave to remain, you have to be very careful. And I will suggest you, if you are in a situation where you are not sure what actually your situation is, before making this application, pay a huge amount of Home Office fee, please speak to a lawyer, get advice, and then made an application. My name is again Sohail Ahmed. If you need any assistance, please feel free to contact me. Our contact details is at the bottom of the screen. If you Google SWF Solicitor, you'll find our contact details. We can advise you over the telephone, WhatsApp, or online Zoom meeting, anywhere in the UK. Thank you very much. This is